Bismillahirrahmanirrahim. I seek refuge from Shaitan, the accursed, and start in the name of Allah, most gracious, most merciful. We thank him most sincerely for keeping us alive and in good health, enough to enable us gather here tonight, even if virtually, to take on Module 10 of our drug information series. We beseech him to be with us as we seek to enlarge our knowledge base for a better pharmacy practice, inshallah, bi-qudratillah. Amen.
Amen. Thank you for that prayer.
Amen.
May God answer our prayer. Thank you so much. We want to welcome all of us to this meeting. We recognize our fellows of PSN, fellow of WPC, our lecturers, our senior colleagues. You are all welcome to this meeting. The lecture today is titled The Legal Aspects of Drug Information Practices. And the speaker is OJO Samuel, a young pharmacist from University of Ilorin. And I will call on him to start the lecture. Samuel, while waiting for the moderator to join us, so I want to call on the speaker. So please go ahead with his lecture, please. Mr. OJO Samuel, kindly go ahead. Or meet yourself and start the lecture.
Good evening, sir.
You are welcome.
A wonderful evening to every one of us. Good evening, sirs and Mars. It's a privilege for me to be here, and I'm optimistic that this lecture will go a long way to adding positive impact to the profession at large and to give us extra competence in areas needed. The lecture will progress alongside a presentation that I'll be sharing. Can you just give me a minute, sirs, and Mars, to share a slide? Hope I'm still connected, sir.
You are. Yeah, go ahead.
Okay.
Kindly go to the slideshow for it to be bigger. Yeah. Slideshow. Yeah, down, yes, click on that.
Okay.
Okay.
So, good evening, everybody. Today, I'll be discussing regarding the legal aspects of drug information practices. And this is a very crucial aspect of the drug information field or aspect of pharmacy. And this is a very condensed lecture in the sense that there are a lot of things that because I didn't want it to have too much excess detail, I had to leave it out. So I'll just be touching the very crucial aspects, and this is the outline of what I'll be discussing on. A brief introduction. We'll be talking about the torts law, which is a very important law in the aspect of drug information. We'll be taking a case study. We'll be looking at types of liability that are possible, defenses to negligence and malpractice protection, protecting against malpractice, labeling and advertising liability, and we'll be also seeing other areas of concern as regarding these subjects. Then we'll finish with some conclusions and recommendations. So straight to the discussion and the lecture. An understanding of the legal aspects of drug information can help practitioners in day-to-day practice, as well as provide some possible ways to protect him or herself in the legal system. I'm very sure none of us would like to have a litigation against us, as we move ahead in the profession. No one would like to incur extra costs or a problem as we continue in the profession. And so it is very important that we are aware of this subject, especially when it comes to drug information. Because as we'll see later on in the lecture, this aspect is necessary that we have adequate knowledge, because if we don't, there are some litigations that can be filed against us that we might not be able to defend ourselves, and we might not know the right steps to take. And so this lecture will equip us with adequate knowledge that we need to be able to defend ourselves and to know what ought to be done and what ought not to be done. So there are a myriad of legal issues confronting the various facets of drug information. These legal issues cross over a number of traditional legal specialties, including computer law, advertising law, privacy law, intellectual property law, telecommunications law, and torts law. It's very important for me to note here that unlike how pharmacy profession was done in the in history and in old times, the profession is gradually evolving, and many other things are now being integrated into the pharmacy protection. We have greater use of robotics and technology, and all these things, although they could stand independently on their own, they are now ingrained into the profession of pharmacy, especially drug information services, because most people, a study showed that most consumers get drug information by electronic means from the internet. And even the drug information provider, most of our resources are starting to be online resources and electronic resources. And so this has expanded the profession, and all these aspects mentioned are things that we'll be considering in the course of the lecture. And so functions of the DI specialist has evolved over the years, as I've explained, and now includes a wide range of services such as online searching, monitoring or recommending drug therapy, patient counseling, participation in clinical studies, participation in pharmacy and therapeutic committees, drug use evaluation, and identifying adverse drug reactions, all of which entail legal obligations of proper performance. And so every one of these areas have a legal aspect to it. It would be a great disadvantage if we we are in the profession and we don't know possible problems that could come ahead. And so that's why we are considering this subject today. So I'll go straight to the first and a very important law when it comes to the subject of drug information. As I can say in a broad sense that every pharmacist is a drug information provider, but there is also a specialization which you can go into, which is you being referred to as a drug information specialist. And if drug information services should be provided by all pharmacists, we must all be aware of some basic things that affect every one of us as pharmacists. And one of the laws that is very important in this case is the torts law. The torts law is a body of law encompassing negligence. And a tort can be defined as the violation of a duty imposed by law on an individual based upon a relationship to another individual. And so essentially, duty in a relationship could be in two forms, basically, which is a duty which is owed, for example, a healthcare professional to a patient, or a duty that is not owed. And in this, an example of this is a passerby to an injured person. And so a pharmacist cannot claim to not want to provide some certain information in some certain cases, because it is a duty that is owed, especially if the pharmacist is being employed. And if it is not a non-governmental organization or a freelance pharmacist, the pharmacist is usually under contractual obligation to provide some certain services. And so it is important that these services are provided in the prescribed format that is standard. And so currently, most litigation concerning pharmacists involve negligence. And it is safe to assume that a legal cause of action pertaining to the provision of drug information will be founded on the theory of negligence as the direct or proximate cause of personal injury or death. Let me quickly give a note on this. It is very important that the error or the negligence on the part of the drug information provider, either a generalist, that's every other pharmacist, or a drug information specialist, must have a direct link with harm or injury that is being caused. Give me a minute, please, as I look for a note I jotted down here. Okay, now there is always a link. Am I still on, sir? Hope it's still connected.
You're on, please. Go ahead. You're on.
Okay, thank you. It's very important that we don't just allow ourselves to suffer losses or litigations when we can actually be exonerated by reason of knowing having knowledge of linkage. If the injury that was caused cannot be directly linked by the plaintiff, when I talk about the plaintiff, I mean the person that is raising the litigation against the pharmacist or the drug information provider. If this person cannot actually establish the link between both phases, it is possible and it is most likely the case that the pharmacist or the drug information provider will be exonerated. And so malpractice liability based on negligence refers to failure to exercise the degree of care that a prudent, reasonable person would exercise under the same circumstances. And so there are certain elements of negligence, and it includes the 4Ds. The first is duty breached, the second is direct causation, and the fourth is defense's absence. What these outlines actually mean. And so once the duty of care is established, the plaintiff would need a preponderance of evidence, that is, a greater weight of evidence, a sufficient weight of evidence to prove these certain outlined points. And before I go to these certain points, I would like to establish the fact that duty of care is something that might not be uniform in all areas and in all countries. Nevertheless, there is a standard to establishing duty of care. Traditionally, physicians remain responsible for their patients and must exact due care. And that means that a physician who knows or should have known that the information provided was improper must be held liable for negligence. And so this brings us to understand that there is actually a standard that we can see generally in different countries and in different establishments. So when the duty of care is being established, and usually this is established when the functions of different pharmacists are compared in different places. In the US, for example, certain areas are not exempted because they are local areas. The law that applies to pharmacists in very developed areas also applies to pharmacists in not very developed areas. And so this brings a greater likelihood of litigation coming against anyone that is found to be negligent. And although in Nigeria, let's say due to the fact that many patients don't have enough financial ability to fight a case, or they are not aware of their rights, many patients might just overlook some losses that they incur from the negligence on the part of the pharmacist. But in other parts of the world, and even in Nigeria, people are starting to get to know more of their rights, and it is possible that a lawsuit could be raised against a pharmacist. And so we'll go briefly into the outlines here. Number one, the information provided was materially deficient. And this explains that if the plaintiff can establish that the information provided by the pharmacist, or in this case, the drug information specialist, was materially deficient, we can say we are establishing that negligence has been is a case in this particular subject. The second is the deficient information was a proximate cause of injury that was suffered. I mentioned this earlier when I was talking about a direct link between the injury and the information provided by the pharmacist. Thirdly, is the recipient reasonably relied on the information provided. The plaintiff must be able to establish that the person that suffered the injury relied on the information that was provided. Fourth is the information deficiency was due to failure to exercise reasonable care. And this brings us back to the fact that the duty of care must be established. Some courts will establish the duty of care of a pharmacist by consulting other drug information specialists, or by consulting colleges of pharmacy to know what exactly the standards of the profession are, or to consult the governing council, like in Nigeria, the PCN. And lastly, the pharmacist knew or should have known that the safety or health of another may have depended on the accuracy of the information provided. And so let's quickly look at a case study. A case study will actually give life to the discussion and the lecture. It's going to help us look at a real life or a real-time scenario and what could have possibly happened and how the pharmacist could have defended himself, him or herself. So the anticoagulation clinical pharmacist receives an order for enoxaparin in a patient who is receiving warfarin. The patient's current INR is 5.2, and the anticoagulation, which is actually quite high. The anticoagulation pharmacist is a board-certified pharmacotherapy specialist, and the pharmacist dispenses the enoxaparin, and the patient is harmed. Some questions we are considering is: one, what factors favor finding the pharmacist liable for negligence? Two, is the prescription dangerous as written? Three, is the specialist more liable than the generalist? In this case, the specialist is a drug information specialist, and a generalist is a pharmacist who is not a specialist in drug information provision. And fourth question is, who may be liable in this situation? The pharmacist, the physician, or the clinic? Now, it is proper understanding of the legal aspects of drug information provision that will enable us to answer these questions accurately. Some things I would like to point out before going further is the drug information provider in this case is a clinical pharmacist. And this brings a lot of things to mind. For example, first, we know that the objective data of that patient ought to be available to that pharmacist. And if the objective data in terms of lab reports are available to these pharmacists, there is a greater possibility of litigation because the pharmacist has no excuse that he was not aware of some certain lab reports since they were available, except if these lab reports were not available in, the patient's records. And so what factors favor finding the pharmacist liable for negligence? One of it is that this pharmacist is actually a clinical pharmacist who has access to the patient's records. And also, is the prescription dangerous as written? This brings to consideration that the pharmacist must be qualified and know what actually must be done in this kind of case, because the patient is actually at risk, and the pharmacist cannot just assume to say dispensing the medication would be all right. And also the third question that says, is the specialist more liable than the generalist? From my study and from my research, it has been proven that drug information specialists actually have greater likelihood to receive litigation than other generalists, because the drug information specialists provide information to some key health professionals, like the doctors is part of the pharmacy and therapeutic committee. And so any slight error can actually have a great impact. And so litigation is more likely in the case of a specialist than a generalist. And lastly is who may be liable in this situation: the pharmacist, the physician, or the clinic. Now, this we cannot have a one-size-fits-all answer for this particular question, because it depends on the organization where the pharmacist is working or where the drug information specialist is working. As we'll see later in the lesson, some organizations actually provide some protection against their employees. For example, in a governmental institution, it is possible that the government gives protection for their employees. Not in all cases, but this gives peculiarities in different cases. And so we must be able to recognize these peculiarities and know who will receive the greater weight of the loss. So the pharmacist's duty to warn of foreseeable complications of drug therapy is becoming a recognized part of the expanded legal responsibility of pharmacists. Where the patient is at higher risk than the general population, the courts have uniformly found liability. Some a specific category of the population, for example, a pregnant woman, for example, patients that have liver cases or kidney cases. These are patients that are at higher risk of suffering injury from some certain medications or information that have been provided. And so it is important that the drug information provider must take note of these certain cases. Today, pharmacists providing drug information, and be they generalists or drug information specialists, are more likely to be held liable, are most likely to be held to the same standards as physicians when determining standard of care. Recent cases against pharmacists have held that pharmacists who gain information about the unique susceptibility in a case, Dooley versus Everest, the courts held the pharmacist liable for failing to warn a patient of the interaction of the theophylline with erythromycin that produce seizures and consequent brain damage. Please, I don't know, am I still connected? Is
Yes, you are
everyone
connected. You are connected and you are being heard clear and loud. Please go ahead.
okay? Thank you, sir. I would continue as we consider the various types of liability, but I would just like to establish a certain note before we go further. Pharmacy practice today has actually evolved from product-oriented practice to patient-oriented practice. And this has required pharmacists to put their patients into consideration when dispensing medication or when providing drug information. In addition to the drug information specialist, the pharmacy profession is assuming an increased legal responsibility to provide drug information in daily practice of pharmacist supervised patient care. And even I realized something from research that 41 to about 83% of requested information is actually patient specific or judgmental in nature. And so we must be very careful as pharmacists not just to provide information carelessly. For example, someone calls in and says he needs information about a certain drug. Most likely that information will be patient specific, because if the pharmacist does not take the patient into consideration, the information provided might not be accurate or might not lead to effective therapy, because the patient is the subject in this case and must be fully considered. And so let me go straight to the types of liability. But because of time constraints, we are only going to be considering 3. I would like to repeat that this presentation is actually a very, let me call it a ultra condensed form of the legal aspects of drug information provision. And so If we would like to have deeper understanding regarding these aspects, we need to actually read further. And so I'm just going to be talking about some major points that will give us a proper foundation in this area of drug information provision. So we have the torts liability, the vicarious liability, and we'll also be talking about the labeling and advertising liability. There are a number of ways concerning torts liability, there are a number of ways in which torts liability can relate to the provision of drug information, and they include incomplete information, inappropriate quality information, outdated information, inappropriate analysis, and dissemination of information. And so in these cases, we'll notice that there is a lot of reference to information. And information negligence is a vital aspect of drug information provision. Information negligence may occur either because of parameter negligence. In this case, when I talk about parameter negligence, I mean failure to consult the correct source. For example, when you are trying to get a therapy for a patient and a pharmacist consults online sources, and most of these online sources, some of them might not be fully accurate because, some people just post things out of, desire to just post something online, but not all these sources are credible. And also, information negligence could be in the form of omission negligence. And in this case, a drug information specialist will consult the correct source. However, will fail to locate the correct answers. And so, for example, I'm using my MDEX and I check information regarding a particular drug, and I omit or I fail to recognize some certain things which I should have taken note of. In this kind of case, it is an omission negligence in the area of information. So going next is vicarious liability. Now, this is also a very crucial aspect when considering liability. Cases of vicarious liability are not new to medical malpractice, because vicarious liability is the attribution of liability on one person for the actions of another. This is crucial because many pharmacists today or drug information specialists are actually being employed by another organization or by, a specific, what will I call it now? A specific person employed that pharmacist. And so it's important that the pharmacist knows that although he or she is employed, he or she can still suffer liability while being employed. And I'll explain this as we go on in the presentation. Through the doctrine of vicarious liability, a pharmacist could become associated with professional liability actions as part of a case against a hospital or physician. And so in some cases where a litigation is brought against the hospital, the pharmacist could also suffer loss, or the drug information specialist could suffer loss because he's one of the key personnel that provides information for the care of patients. Going next is delegation of authority actually does not mean application of responsibility. Under vicarious liability, a pharmacist who has not been personally negligent could be held responsible for the negligence of others. I gave an example here: supervision and advocate training of subordinates. Example is interns, pharmacists, technicians, and other employees are actually essential. Incompetence and substandard training of these individuals can lead to liability. An example might include a breach of confidentiality. For example, revealing someone has a loathsome disease, for example, HIV or cancer, by one of the employees, and this could lead to, a loss or a problem on the side of the person that was harmed. So we are going next to defenses to negligence and malpractice profession. We have been able to consider the torts law and negligence, but how can we defend ourselves against negligence and malpractice in the general sense? Even if the plaintiff can establish all the necessary elements of negligence, legal defenses can avoid or reduce liability. And this is actually the focus of this lecture, that we as pharmacists know actually how we can protect ourselves against these litigations. So some defenses might include a statute of limitation, in this case, a written document that gives a protection, that gives a legal protection to the drug information provider or the pharmacist. Another one is comparative or contributory negligence, informed consent, or governmental immunity. I was trying to talk about this earlier, that some governmental organizations could actually give immunity to the employees. So we must know the framework of the organization that we are working in. And so comparative negligence, as referred to in this slide, is actually the allocation of responsibility for damages incurred between the plaintiff and the defendants. In these cases, the damages is splitted and both the plaintiff and the defendant bear the losses. And it is based on relative negligence of the two parties. But there is also something I didn't mention here. There is also something called concurrent negligence, which is the wrongful act or omission of two or more persons acting independently but causing the same injury. So, for example, the physician, the nurse, and the pharmacist could all suffer litigation. And in this case, it is a concurrent negligence on all their parts because they are all suffering the loss of this certain injury that was incurred. So protection against malpractice. Protection methods to protect against lawsuits include contracts covering financial arrangements, adequate documentation, disclaimers or exculpatory clauses. An example is a disclaimer can be placed on the results of online searches stating that the data being provided are from a source believed to be reliable and factually correct. And the last is insurance. I would not want to assume that we get the gravity of all these points, so I'll just say some things briefly about them. Documentation is actually very, very important when it comes to drug information provision, because we must not be careless as pharmacists. For example, in the case of the hotline, where a pharmacist provides information or an email provides information via some certain sources, and these things are not actually recorded. In a case where the subject or the patient is harmed, or the person, the drug information provider is, the drug information recipient is harmed, this person could actually bring a lot of accusations against the pharmacist. And if the pharmacist cannot provide adequate documentation that these things are not true, it is possible that the pharmacist could suffer loss. And so for every information we provide as pharmacists, it will be wise for us to actually document these things. For example, recording the call, or recording the recipients will not just be able to bring up things that the pharmacist did not do out of the blues. Another one here is disclaimers. For example, the reference that I used for this presentation actually made it so clear that the information provided was not a substitute for legal advice. And this was a protection on the size of the resource I consulted, because it actually frees them from a lot of problems which could come in the future, where a person could say, I relied on this information, however, I suffered loss. And lastly is insurance. There are certain insurances that could actually help to pay for, or to protect a drug information provider against litigation, even when the pharmacist was found to be at fault. And so information is very important, especially for a drug information specialist, because this kind of person will require greater insurance in case anything goes wrong in the future. So protection against malpractice. The key to provision of quality drug information in an information service is the availability of current objective information. And the drug information specialist must not run on old information. We must always be current as pharmacists to know what is being changed. For example, new adverse drug reactions that are coming up, to be able to provide accurate and effective information. And so we must always be current. Procedures should be in place to ensure that data is continually being reviewed and updated, especially for a drug information resource center. Quality assurance standards for the timeliness, thoroughness, and accuracy of information could also insulate against liability. I would like to emphasize on quality assurance because many drug information centers do not have standard operation procedures that they run by. Just like in an industry where everything done is, number one, documented, and number two, there is a standard operation procedure for everything that is done. So also in a drug information center, there should be a standard operation procedure for how queries are being handled. So there should be certain procedures where the person that is working will know what resources to consult, what platforms to use to dispense the information that is being given, and so many other things, so that the pharmacists going by these standard operation procedures will not miss out any important step. So let's go further so we cap up the lesson. There is also labeling and advertising liability, and there are at least 3 key areas of labeling and advertising liability. Number one is the learned intermediary rule, which is a defense to failure to warn action. In this case, it is possible that the pharmacist is the one that is advertising, and it is possible that the advertisement is just through, media sources like the television, a commercial, or just a Facebook ad. In this case, the Facebook ads, the commercials are unlearned, and they would suffer lesser, there is less likelihood for them to suffer litigation than when it is the pharmacist advertising. In many cases, as pharmacists, we must be careful when we are advertising. And I see a lot of this as an issue where drug representatives or company reps come that pharmacists advertise their products for them. They bring a lot of incentives, they buy a lot of things. And we must be careful because when we advertise for them and something goes wrong, we would most likely suffer the loss if litigation is raised against us. And so we must be careful. The second is the doctrine of overpromotion, under which adequate warning is alleged to have been diluted by communications failing to adequately convey the full impact of the warning. In this case, for example, it is not very advisable to get drug information from a site that is being handled by a drug company, because they might most likely overpromote their products and want people to get to use it and leave out certain information. And so we must be careful in this area. And thirdly is promotion of off-label use or FDA unapproved indications. So going next is other areas of concern. Because of the time constraint, I'm just going to mention them. We have the internet and the web information. We have the telemedicine and cyber medicine. We have the social media. We have the copyright infringements. We have the privacy concerns, and we have industry supports for educational activities. All these areas can actually stand independently, but they are now ingrained into drug information provision. And it is important that we know that there is possible litigation and legal aspects of all these areas. And for the drug information specialist that has to work in any of these areas, it is very important that we are aware of the legal areas relating to them. In conclusion, the future of pharmacists as drug information providers clearly lies in the ability to provide consultative DI services. Pharmacists should not be preoccupied with the risk of incurring liability, but should take the necessary steps to limit exposure and develop an appreciation of modern legal philosophy. The pharmacists cannot claim to not be aware or to be on the ignorant side, because a lot is being demanded from pharmacists nowadays, and we must not claim that we are not aware of these things. And this is one of the major reasons of this lecture. Certain recommendations I'm giving is, first is we must always strive for excellence. Second is we must have good relations with requesters and make sure they are aware of alterations or modifications in information systems and sources. Third is we must make no outrageous claims about accuracy and thoroughness of information provided. In this case, please, I would most likely advise us as drug information provided to always put in disclaimers in cases where we know that this information could most likely bring a problem. For example, we could say this information was retrieved from so source, and so if there is a litigation is raised, it might be easy in the when we are the defendants that the case be passed on to the information source. In this case, if the information source was, let's say, the MDEX, you could say your source was the MDEX, and in this case, you are already passing on the liability to another person or another organization. So finally, pharmacists should carry or have their own malpractice insurance policy. And so we should not only insure our cars, in profession, we also actually need insurance. So this is the reference that I consulted for this presentation, and I am optimistic, and I hope that we have been able to, get a lot of insights and get knowledge from the presentation today. I would like to say thank you for the privilege. Good evening, everybody.
Thank you.
I'm done.
Thank you, Samuel, for a wonderful presentation. You did a very good job. You did justice to it, and I'm sure most of our colleagues have learned a lot on the legal aspects of drug information.
Thank you.
While we are raising our hands, we're about to go into the question and answer session. While we are raising our hands, I would like to, first of all, acknowledge the presence of our fellows in-house, fellows of PSN, fellows of YPG, all our senior colleagues, all our esteemed colleagues in-house. You're all welcome to this presentation. Okay, I can see some hands raised up. This is the time for questions and answer. I call on Pharmacist Margaret Afolabi to ask her question. You can unmute yourself and ask your question.
Thank you very much. I want to appreciate Dr. Samuel for the beautiful presentation. My name is Professor Afolabi from OAU Ile-Ife. And there are some salient points, one or two of which I actually want to point out. It has really been a great learning forum. The lecture actually emphasized the importance of pharmacist supervision and our oversight function. I could bring this out when he was explaining the vicarious liability. In other words, there is no way we can abdicate ourselves from the responsibilities. Even if we are not there as pharmacists, or we are there, or we just allow the pharmacy technicians or the sales get to hand over the medication to the patient. So I think these aspects of the liability, actually becomes very, very imperative. So I really thank you for bringing this up. Then the other one which I quickly want to bring up is the need for us to actually be conscious of the legal implications of our practice, particularly now that we are having specialist pharmacists. Because if we claim to be specialists in a particular area or in particular therapeutic area, that means that we are, to all intents and purposes, assuming more of the responsibilities of the duty of care. So I gained a lot from this presentation. And once again, I say thank you very much for this opportunity.
Thank you, Professor Margaret. I'm so sorry about the first introduction. Thank you, Professor Margaret, for your comments and your contribution to this topic. Any other person? Does anybody have any question or contribution to make? Hello, any questions, any contributions? Okay, in the absence of any more questions and contributions, I'm quite sure that most of us have learned, and we are going to be more careful in our passing across drug information to our patients, our clients, and from now on. At least now we have our frequencies, we know where implications of what.
Sorry, network issue. I think we are gradually going to the end of the lecture, and our moderator has a network challenge. So maybe at this point, I would like to call on our lecturer, Professor Margaret Afolabi, to please close this meeting with prayer, ma'am. Good evening, ma'am. Can you help us close this meeting with prayer, ma'am? Professor Afolabi, ma'am. Okay, no more with us. At this point, we'd like to end the meeting. We lost the moderator. I think we have come to the end of the meeting. So we just want to close with prayer. Okay, let me call on Dr. Adelonke. Olu, can you please close this meeting with prayer? Kindly go ahead and unmute yourself. Dr. Adelonke, if you are still online, please go ahead. Yeah.
Good evening, everybody. Shall we pray?
Please, go ahead, please.
Lord, we thank you for today's meeting. We thank you for the topic that is so relevant that you have brought to our knowledge today. The grace to practice right, Lord, give unto us in the name of Jesus. We also ask that our presenter, you continue to anoint him for better in the name of Jesus. As we go to sleep, pray we'll sleep in peace and wake up in peace to the glory of your holy name. In Jesus' mighty name, we have prayed. Amen.
Amen.
Amen. Thank you. Please kindly drop your email address so that we can fast forward the slides and video recording of this lecture to you.